Sign the transfer, or you will never hear from us again. My brother did not knock. He walked into my apartment like he still owned the right to. Dropped a manila folder on my kitchen table, and pointed at it the way you point at something you have already decided belongs to you. Inside was a transfer of beneficial interest form. Our grandmother's investment portfolio. $142,000 CAD. The money she had spent 40 years building through GICs and dividend reinvestment. The money she told me on her last hospital visit was meant to give me a head start, not a bailout for anyone else. My brother Marcus was standing there in his Canada Goose jacket, arms crossed, jaw tight. Our mother was behind him in the doorway, still in her coat, holding her purse with both hands like she was bracing for impact. They had not called ahead. They had not asked how I was doing. They had driven 2 hours from Oakville to my apartment in downtown Hamilton on a Tuesday night, and they expected me to pick up a pen. I did not pick up a pen. I looked at the folder, and I looked at my brother, and I felt something inside me go very, very quiet. My name is Claire. I am 31 years old and I am a licensed forensic accountant. My job is to sit inside companies that smell like desperation and find the exact place where someone decided the rules did not apply to them. I find the hidden transfers. I find the doctored invoices. I find the moment greed overrode judgment and left a paper trail behind it like breadcrumbs. I do this professionally. I am very good at it. And I had spent the last 3 weeks doing it to my own family because something about the way my grandmother's estate had been handled since she passed in September had felt wrong in a way I could not explain at first but could not stop thinking about. To understand why I did not throw them out immediately, you need to understand how our family was structured. My grandmother Margaret had 2 children, my mother Patricia, and my uncle Dave, who moved to Vancouver 20 years ago and mostly stayed out of things. My mother had 2 children, Marcus, who was her project, her investment, her proof of concept, and me, who was her plan B, that she never really needed and therefore never really wanted to use. Marcus was 3 years older, built like a rugby player, and had been handed every advantage our mother could manufacture: private school tutoring, a down payment on his condo in Mississauga, a co-signed car loan when his credit was too thin. My mother gave him these things not because she was generous but because Marcus's success was her success. His wins were her wins. When he got a promotion at his wealth management firm, she told her friends at her book club before she told me. When his marriage fell apart 2 years ago, she told me it was partly my fault for not being more supportive. I was not the favorite child. I was the responsible one, which in our family meant I was the one who was useful when something needed doing, and invisible when something good was being handed out. I helped my grandmother with her taxes every spring for 6 years. I drove her to her cardiologist appointments when my mother was busy. I sat with her on the last night she was conscious, and held her hand while my brother was in Las Vegas at a client golf tournament he said he could not reschedule. She told me that night that she had spoken to her estate lawyer. She said she wanted the portfolio to go to me directly, not through my mother, because she knew how these things went in our family. She said it clearly. She was not confused. She was 83 and sharp, and she had watched her own daughter's financial management habits for decades. She said the portfolio had a beneficiary designation. She said my name was on it. She said I should call her lawyer, a woman named Renata Ferreira, after the service. My grandmother died at 4:17 inches the morning. I was still in the chair beside her. 3 weeks later, when I called Renata Ferreira's office, the receptionist told me the beneficiary designation on the portfolio had been changed. 11 days before my grandmother died, when she was already in palliative care, when she had not left that hospital room in 2 weeks. The new beneficiary was a numbered company. I wrote the number down. I told the receptionist I would be in touch. I hung up the phone and sat in my car in the parking garage for a long time. Then I went to work. A numbered company in Ontario is not difficult to trace if you know how to read a corporate registry. The company had been incorporated 4 months earlier. The sole director was listed as Marcus David Whitmore, my brother. My mother was listed as the registered agent. The address on file was my mother's house in Oakville. The portfolio had not disappeared. It had been moved. Through a document, my grandmother almost certainly did not sign herself, into a shell company, controlled by the 2 people who stood to benefit most from it. I did not call my mother. I did not call Marcus. I opened a new folder on my desktop and I started building a file the way I build every file, chronologically, methodically, with every document, every timestamp, and every signature discrepancy I could find. I ordered a copy of the original beneficiary designation from the financial institution through a formal request. The signature on the change form was my grandmother's name, but the handwriting was inconsistent with the samples I had from the 6 years of tax documents she had signed in front of me. The date stamp showed the form had been submitted by fax. My grandmother did not own a fax machine. She had not owned one in 15 years. The fax origin number traced to a UPS store location in Oakville, 4 blocks from my mother's house. I saved everything to 2 external drives and a secured cloud folder. Then I called a lawyer. His name was Gordon Achterberg, and he had been practicing estate litigation in Ontario for 27 years. I had used his firm once before on a client file. He was methodical and deeply unimpressed by people who assumed the law would bend for them. I liked him immediately. I told him what I had found. He was quiet for a long time. He said, "Claire, if what you're describing is accurate, we are looking at fraudulent alteration of an estate document, potentially elder financial abuse under the Substitute Decisions Act, and possible forgery." He said we needed to move carefully. He said we needed to let them believe nothing was wrong for a little while longer. I asked him how long. He said, long enough to see what they do next. They came to my apartment 11 days later. I looked at my mother in the doorway, and I thought about my grandmother's hands. The way she folded them in her lap during our tax sessions. The way she always made me a cup of red rose tea before we started. The same brand she had been buying since 1974. I thought about how she had called my mother twice from the hospital in the last month. And my mother had visited once, for 40 minutes, on a Sunday afternoon when she had other plans afterward. I let my shoulders drop. I exhaled slowly through my nose. I have a particular skill, developed over 10 years of sitting across from people who have done things they should not have done, which is the ability to look like I am processing something emotionally, when I am actually cataloging every detail of what is in front of me. I said, "I don't understand. I thought she wanted me to have this." My brother said Grandma was confused at the end. He said she had talked to a financial advisor, meaning him, about restructuring the portfolio for tax efficiency before she passed. He said the numbered company was just an administrative vehicle. He said I would still benefit, eventually, once the estate was properly settled. He said this the way people say things they have rehearsed, smoothly, with just enough technical language to sound credible to someone who did not know what they were talking about. I did not tell him that I had spent 11 days learning exactly what he was talking about. I said, "I just want to make sure I'm not going to have a tax problem. If there's money coming to me, I need to document it correctly. My firm has compliance rules." My mother softened immediately. She said, of course, that's exactly right. We just want to handle this properly." I said, "The issue is that if this is treated as an inheritance, it flows through the estate tax-free under Canadian law. But if it comes through a corporate entity, and I'm listed as a beneficiary of the company, CRA might treat it as a shareholder benefit. I could end up with a surprise tax bill." Marcus frowned. He said that wasn't right. I said, "I know. It seems counterintuitive. But the way around it is simple. I just need you to confirm in writing that the portfolio transfer was always intended for my benefit and that the corporate structure was administrative, not substantive. If you sign a simple letter of direction stating the funds were designated for me by Grandma, and the company was only used as a transfer mechanism, it protects all of us from CRA scrutiny." I watched Marcus turn this over. I watched him look for the trap and not find it because he was looking for the wrong kind of trap. He was looking for something that would cost him money immediately. He did not understand that I was building something that would cost him everything, and I needed his signature on the foundation first. I opened my laptop. I had the letter of direction prepared. Gordon had reviewed it. It looked exactly like what I said it was. A routine administrative document, clean and boring, formatted like a CRA compliance memo. But in the third paragraph, under a heading that said Purpose of Transfer, there was a line that read, "The undersigned confirms that the portfolio assets were designated by the original account holder for the exclusive benefit of Claire Ann Whitmore prior to the beneficiary change of date, and that the corporate structure utilized was not intended to alter, diminish, or redirect those designated funds." If Marcus signed that, he was confirming that he knew the original designation existed. He was confirming he knew the funds were meant for me. He was confirming the corporate structure was used to move money that was already promised to someone else. He was handing me the element of intent that turns a civil estate dispute into something the Ontario Provincial Police Fraud Unit finds interesting. I emailed the document to his phone while he was still standing in my kitchen. He read it on his screen. He asked one question about the CRA reference in paragraph 2. I answered it confidently and technically, and watched his eyes glaze over in the way that eyes glaze when someone smart-sounding is explaining something that sounds plausible. He was a wealth manager. He knew financial language. He also knew just enough to be dangerously overconfident about what he understood. He signed it. DocuSign. Time-stamped. IP address logged to his cell carrier's tower in Hamilton. Legally binding under Ontario's Electronic Commerce Act. My mother signed as a witness. I said I would get the funds sorted by end of week. I said I needed a few days to clear the internal compliance process at my firm. I told them to go home and I would be in touch. My mother hugged me at the door and said I was being so mature about this. I locked the door behind them. I stood in my hallway in the dark for a moment. Then I forwarded the signed letter of direction to Gordon Achterberg's secure email along with my existing file. I wrote one line. "We have what we need. Please proceed." Gordon filed the notice of objection with the estate trustee the following morning. He sent a concurrent complaint to the Law Society regarding the notarization irregularities on the beneficiary change form. He also sent a formal letter to the financial institution flagging the fax origin discrepancy and requesting a freeze on the portfolio assets pending investigation. Then he called me and told me to get ready for the meeting. It was held 12 days later in a boardroom, on the 14th floor of a building, on King Street West in Toronto, floor-to-ceiling windows. A gray November sky over the lake. The kind of room designed to remind you of consequences. Gordon had arranged it as a voluntary mediation before any court filing. He framed it to my brother's lawyer, who was a junior associate at a Bay Street firm and looked deeply uncomfortable, as an opportunity to resolve the matter without litigation. My brother and mother thought they were coming to negotiate. They thought I was going to ask for a portion of the portfolio and accept a settlement to avoid the cost and stress of an estate dispute. They thought the signed letter of direction was a nuisance, an administrative thing Gordon would wave around for leverage before I took a check and went home. They did not know about the rest of the file. I arrived 10 minutes early. I wore the gray blazer I wear to client presentations. I brought nothing except a thin portfolio folder and a bottle of water. Gordon was already there, sitting at the far end of the table with his associate, a woman named Priya, who handled the documentary evidence and had color-coded every exhibit. My brother came in first. He looked confident. Annoyed, but confident. He sat without making eye contact with me. My mother came in behind him, wearing the expression she wears when she has decided to be disappointed in someone, which she has been perfecting since I was 14. Their lawyer set up his laptop and looked at his notes. The mediator opened the session. She noted everyone was present and reminded the room that statements made in this proceeding could be used in subsequent legal filings. My brother's lawyer tried to object to that framing. Gordon let him finish and then said, calmly, that given what the documents contained, his client would prefer the record to be complete. The lawyer stopped objecting. My brother went first. He said my grandmother had become increasingly confused in her final months. He said she had expressed to him, as her financial advisor, that she wanted her estate handled with tax efficiency in mind. He said the beneficiary designation change had been made with her knowledge and consent, and that she had authorized the use of the numbered company as a holding structure. He said I had been informed of this arrangement, and had agreed to it. He said the letter of direction I had asked him to sign was taken out of context. The court reporter's fingers moved steadily. When he finished, Gordon said, "Thank you." He opened his folder. Exhibit 1 was the original beneficiary designation form, naming me directly, signed by my grandmother 4 years earlier with her estate lawyer present. Exhibit 2 was the change of beneficiary form. Gordon placed it beside the original. He pointed to the signature. He asked my brother's lawyer whether his client would like to explain why the signature on the change form did not match the original in 7 specific ways, which Gordon then listed, and why the form had been transmitted from a fax machine at a UPS store 4 blocks from my mother's address 11 days before my grandmother's death, during a period when she had not left her hospital room. The lawyer looked at Marcus. Marcus looked at the table. Gordon said, "I would also like to note for the record that my client's grandmother was assessed by her attending physician as having diminished cognitive capacity beginning 6 weeks before her death, a fact documented in her medical file, which we have obtained through proper channels. Any legal document executed during that window is presumptively suspect." My mother said that was not true. She said my grandmother had been perfectly clear. Gordon placed Exhibit 3 on the table. It was the physician's assessment. It had a date on it. The date was 3 weeks before the beneficiary change was submitted. The room went quiet, in a way that rooms go quiet when the temperature drops suddenly. Gordon placed Exhibit 4 on the table. It was the letter of direction my brother had signed in my kitchen. Gordon read the relevant paragraph aloud. He read slowly. He got to the part that said the corporate structure was not intended to alter, diminish, or redirect those designated funds, and he stopped and looked at Marcus over his glasses. He said, "By signing this document, you confirmed you knew your grandmother had designated these funds to your sister. You confirmed the numbered company was used as a transfer mechanism for funds already promised to her. Combined with the evidence of the forged fax and the cognitive assessment, we are no longer in the territory of a disputed estate interpretation. We are in the territory of fraudulent misrepresentation of an incapacitated person's estate wishes, which in Ontario is an offense under the Succession Law Reform Act and potentially under the Criminal Code." Marcus's lawyer put his pen down. My brother looked at me for the first time since he walked in. He looked at me the way people look at something they thought was a minor obstacle, and have just realized is a wall. I looked back at him, and I did not feel angry. I had expected to feel angry. Instead, I felt the clean, flat calm of a file that is correctly completed. Gordon slid a document across the table. He said, "My client has prepared a resolution agreement. It requires 3 things. First, the numbered company is dissolved, and the full portfolio is transferred to Claire Whitmore within 14 business days. Second, Both of you sign a statement acknowledging that the beneficiary change was not executed with proper authorization. Third, a no-contact provision. You do not contact my client. You do not attend events where you know she will be present. You do not involve mutual family members as intermediaries. Any violation of the no-contact provision, and we file the full package with the Ontario Provincial Police Financial Crimes Unit and the Law Society, and my client gives a complete statement. And if we refuse, my mother said. Her voice was thin. Gordon looked at her pleasantly. Then we file tomorrow. And your son answers questions about the fax machine. My mother looked at Marcus. Marcus looked at his lawyer. His lawyer looked at the ceiling. Marcus signed first. His hand was steady, but his face was not. My mother signed without reading it. She kept her eyes down. She did not look at me again. I stood up. I picked up my portfolio folder and my water bottle. I thanked the mediator. I shook Gordon's hand. I walked out into the hallway and pressed the elevator button and stood there in the gray November light, coming through the window at the end of the corridor. I thought about my grandmother in the chair by the window in her hospital room, the way she said my name when I came in, how she always knew the sound of my footsteps. The elevator opened. I got in. The resolution took effect 3 weeks later. The portfolio transferred cleanly. Gordon's firm handled the dissolution of the numbered company. I paid his invoice, which was substantial, and I considered it the best money I had ever spent. I did not attend Christmas that year. I did not send cards. I changed the contact settings on my phone so their numbers go directly to a folder I do not check. I used part of my grandmother's portfolio to pay off my student debt. I used another part to open an RRSP. I put the rest into a TFSA, and I left it there, the way she would have wanted, growing quietly in the background of a life that finally belongs to me. My grandmother was not confused at the end. She knew exactly what she was doing when she told me to call Renata Ferreira. She knew what her family was capable of, and she tried to protect me from it. I think about that sometimes. How she had watched this family for 83 years, and she saw it clearly. How she tried to leave me something that could not be taken. I just had to make sure it could not be taken. Have you ever had to use the one skill they never expected you to have just to keep what was already yours? Tell me in the comments. And if you're reading this from somewhere cold tonight, tell me what city you're in. I want to see how far this one travels.